Before we get started, just to make sure you all know, if you do want to see the slides or listen to this again, just to liven up your spring break, this is going to be recorded. It will be on the firm's health law blog. And so if you need to access any of the materials from this after the fact, you can do that. It should be up in the next day or two. So with that, why don't we go ahead and get started? If you do have questions, feel free to type them in. We'll probably end up answering those by email later on. Typically, we don't have time to get into those, but if we do, and if we can, we will do that. But if not, we'll answer those by emails. But if you do have questions, feel free to type those into the Q&A box, and we will go from there. All right, so let's get started. First of all, what are we talking about when we talk about antitrust law? Antitrust law really governs the realm of competition. And as you can see here from the we've got two quotes from the two federal agencies that really focus on antitrust law, the Department of Justice and the Federal Trade Commission, about antitrust law and what it is and what it's designed to do. The Department of Justice Antitrust Division notes on their mission page that the goal of antitrust law is to protect economic freedom and opportunity by promoting free and fair competition in the marketplace. The FTC similarly notes free and open markets are the foundation of a vibrant economy. Aggressive competition among sellers in an open marketplace gives consumers the benefits of lower prices, higher quality products and services, more choices, and greater innovation. And that the laws promote vigorous competition, protect consumers from anti-competitive mergers and business practices. So we see some common themes in there that this is really antitrust law is designed to protect the free marketplace and allow competition to benefit the participants in the marketplace. All right, so as we go through today, we're going to, first of all, start off with some key terms. We're going to talk about the basics of antitrust enforcement. And in doing that, we're going to go through several examples of how the antitrust laws are enforced. We'll spend a few minutes going over some specific areas that seem to pop up from time to time in our part of the world as we're dealing with antitrust issues about group purchasing organizations, joint negotiating, boycotts, things like that. And then we'll talk very briefly about what is next. We don't know, obviously, everything. We don't have a crystal ball that tells us what's going to happen in antitrust enforcement going forward. But I can tell you, and as a bit of a preview, antitrust enforcement is something where there really is bipartisan support for change. And you know, the scope and the focus of that change obviously is going to differ from party to party. But I think that if you pop in for next year's webinar discussing antitrust law, I anticipate that there will be some significant changes in antitrust law and antitrust enforcement strategy. So stay tuned. All right, let's first talk about key terms, and the first key term that we need to talk about is the market. As we mentioned from those earlier quotes, the competition within the marketplace is the core focus of antitrust law. And when we talk about a market, what do we mean? This is an economic definition of a market. It's the area within which a firm or a group of firms could profitably raise prices, and that is they could exercise power within that market. To determine what a market is, the FTC, which has been sort of leading the charge on this for the last couple decades, applies what it calls the hypothetical monopolist test. And it looks to whether this hypothetical monopolist could raise prices by a small amount, a small but significant non-transitory increase in price, or SNIP, as it's known. And if a hypothetical monopolist could raise prices a small but significant amount for the long term, then that is the mechanism that the agencies use to define a market. And we're going to talk about a couple different types of markets that we need to consider. The first is the product market and then the geographic market. So the product market is an effort to identify what products compete with each other to some substantial degree that we can say they are within the same market. Courts look at a variety of factors, but really they look at whether you can reasonably interchange those products. And if you can, then they would be part of the same market. If not, they wouldn't be. And that can be very context-driven. We have the example that I have here. You've got automobiles. Some automobiles are four-wheel drive, some are all-wheel drive, some are two-wheel drive. What is a market for those vehicles? Well, it can depend very much on what is at issue in the case. In many instances, a four-wheel drive vehicle may be interchangeable with a two-wheel drive vehicle. And so you would have to consider that for your product market. And let me give you an example. If I'm concerned about a commute from my home to my office, then probably the market that we're looking at is all automobiles versus a marketplace of four-wheel drive vehicles. If we're looking at a market of off-road vehicles, then we're probably going to be more limited than all automobiles. And so it's very context-driven as to whether products are interchangeable, and it varies from case to case. This analysis has been a little bit complicated in the healthcare arena because we have insurers. If a hospital raises prices for services or products that it is providing, those are paid frequently by insurers rather than by patients. And that can really have an impact on how products are chosen and how they're seen as interchangeable. And so that's been complicated by insurers, but the agencies and parties have come to recognize that in the healthcare world and sort of work with it in defining a product market. Again, the key, though, is as we look at these products, are they reasonably interchangeable? If they are, in the context of the case, then yes, they're part of the same market. Next, we move to the geographic market. It's not enough just to look at the product market. If we're concerned about, say, the prices of four-wheel drive vehicles, it may not make much of a difference if I'm here in Salt Lake and somebody in Denver raises the prices that they're selling four-wheel drive vehicles. And so we need to figure out what is the geographic market at issue. And this is the territory in which producers, and this includes potential producers, are located and to which customers can reasonably turn for sources of supply. And so let's look at this in the context of the hypothetical monopolist test. Let's say we do have a hypothetical monopolist who wants to impose a small but significant increase in prices in the market. And so we look at our example. Let's say that we're looking at hospitals that are raising prices on certain services, and we're trying to figure out if Salt Lake County is a proper antitrust geographic market. And so we look at whether the hospitals in that county could profitably raise prices if they were in a cartel, if they were all agreeing to do this, they were going to raise these prices in lockstep. If they did that, what would consumers do? Are consumers going to continue to go to hospitals in the Salt Lake County area and simply pay the higher price, or are they going to go to hospitals in surrounding areas instead? And if they are going to do that, then we haven't correctly defined the market. And so what we would do is then we would expand our hypothetical monopolist test, and we would say, okay, Salt Lake County wasn't a market. Salt Lake County and maybe some of the hospitals to the south and some to the north will add that in. And if we do that, and if all those hospitals were to raise their prices on a particular service, would consumers continue to go to those hospitals? And we would keep doing that test until the answer is yes, consumers would still go to those particular hospitals. They would not leave that market and go to other hospitals, and then we've identified our geographic market. All right. All this, of course, matters only if you have market power, and that is the test that we're looking at. Does an entity or will a combined entity have market power? This is the ability to raise price profitably by restricting output. And the question you want to ask yourself is, can you either raise prices or can you lower the quality of the product or service that you're providing without losing so much business that it becomes unprofitable? And if you can do that, congratulations, you have market power. This can be exercised unilaterally. It can be done through coordinated action among different entities, but that is an example of market power. Again, this is very, that's what market power is. It's very context-driven, and let me give you an example of that. Let's say that I own a gas station in Las Vegas, Nevada, and it is sitting on a corner of an intersection, and on the 3 other corners are 3 other gas stations. And I decide that I am going to raise my prices 10 cents a gallon. That's probably not going to help me because consumers can see the prices on the signs outside of my gas station and the 3 competing gas stations on that intersection, and decide that they're not going to go to my gas station because I charge more. And so I lack market power there because I can't simply raise prices without losing business and having my business become unprofitable. By contrast, if any of you are headed to Moab for spring break, and I highly recommend that you do, you will see that about 15, 20 miles outside of Moab, right as you're getting onto the freeway, there is a single gas station, and that gas station in the past has typically had gas prices that are $1 to $2 per gallon higher than surrounding gas stations in the area. And by in the area, I mean 30 or so miles, because it's the only gas station there. And so people going to the freeway, if they did not fill up in Moab before they left, have only this option. And the owner of the station had realized that he could raise prices profitably and not lose enough business so as to make that unprofitable. And so in that instance, that gas station has market power. Okay. So with those kind of basic definitions, let's go on then and look at the next issue, which is who's looking at antitrust law. I mentioned at the outset that with the federal government, we're talking about the Federal Trade Commission, the Department of Justice. The Federal Trade Commission is really where we focus in healthcare. It has a group specifically to address healthcare issues. The Federal Trade Commission has, over the last decade or so, as with the Affordable Care Act and some related acts and regulations, have really provided incentives for healthcare providers to consolidate and collaborate. The FTC has yet maintained a fairly skeptical view of the necessity to merge or otherwise consolidate to provide more affordable care. And the FTC is the one looking at most of these issues, and so that creates a little bit of tension. The Department of Justice is also involved in antitrust regulation. Generally not so much in the healthcare arena, but it's not unheard of. And one area where the Department of Justice will get involved is in criminal actions. And again, these are not very common, but they do happen. And let me just give you a couple of examples. In December of 2020, just a couple months ago, the Department of Justice announced that it was prosecuting the owner of a physical therapy staffing company in the Dallas-Fort Worth area. And the Department of Justice alleged that the owner of that company had agreed with some co-conspirators to pay lower rates to physical therapists and physical therapist assistants for several months in 2017. And so he was indicted as a result of that, and was also indicted for obstructing the FTC's investigation into that conduct. So that this can be an area where criminal actions are in play. Another example, April 2020, there was a Florida entity, the Florida Cancer Specialists and Research Institute, that admitted it had been involved in a criminal antitrust conspiracy to allocate the market for medical oncology and radiation oncology treatments provided to cancer patients over just under a 20-year period. And so it entered into an agreement, a deferred prosecution agreement with the Department of Justice, agreeing to pay a $100 million penalty to avoid prosecution. It also agreed to pay $20 million in disgorgement in a settlement with the Florida Attorney General. And just this last fall, a federal grand jury indicted the founder of that entity for his role in that market allocation conspiracy. So not all that common, but it's definitely a risk that if parties are engaged in criminal antitrust conduct, there can be criminal antitrust consequences as a result of that. In addition to the federal agencies, state attorneys general are often involved. And I will say the level of involvement varies from jurisdiction to jurisdiction. The amount of antitrust enforcement at the AG level in Utah versus Nevada versus California versus New York are all going to be very, very different. But state attorneys general frequently join in FTC challenges. They frequently reach out to federal agencies for support in investigations. And so you cannot just focus on federal agencies. There's also state law involvement. And finally, competitors can be involved in antitrust issues as well. Competitors can file their own lawsuits. They can report anti-competitive conduct to state or federal agencies, which can lead to investigations. And so they also are going to be looking at these issues and how business is being conducted. All right, so what are the agency's goals in this? Not surprisingly, as we saw from the outset, they are looking to protect the free market. And in particular, under the antitrust laws, their goals are to improve consumer welfare by protecting competition. Now, this doesn't mean that they're protecting any particular competitor. And so, for instance, if I am competing in a marketplace and my competitors all lower their prices and I find myself unable to match their prices and I'm losing business, that by itself is not a concern for the antitrust laws. In fact, the goal of antitrust, well, part of the goal of antitrust law would be to allow competition to weed out bad competitors, leaving only the best competitors to provide the best products, the best services at the best prices for consumers. And so competitors who don't do that are going to be weeded out through the competitive process. And the agencies have noted that competition provides lower prices, better quality, and more output. And that's the goal that they are trying to achieve. So let's look at some of the laws that apply when we're talking about antitrust, and there are many. There are federal and state laws. We're really going to focus on federal laws today. Most state antitrust laws parallel largely the federal antitrust regime, and so there is significant state and federal overlap. But don't think that simply because you have, for instance, complied with federal law, that you have complied with your state law. You need to check that separately, but we're not going to get too much into state law issues today. All right, so let's first talk about the Sherman Act. And there are a couple sections of the Sherman Act we want to focus on. The first one, Section 1 of the Sherman Act, prohibits a contract, combination, or conspiracy among two or more separate entities that unreasonably restrains trade and affects interstate or foreign commerce. Now, if it's a good thing we have unreasonably in there, because every contract in some way, shape, or form is going to restrain trade. When you have an agreement, it necessarily takes some product or service and funnels it into the context of that agreement so that other people can't enter into their own agreements. And so you'll always have some restraint of trade. The question is whether that restraint is unreasonable. So let's give an example of this. In 2016, the Philadelphia Federation of Teachers Health and Welfare Fund sued 3 pharmaceutical companies saying that they had conspired, they'd gotten together and agreed to raise the price of fluosinonide, which I am mispronouncing, but it's a steroid that's used to treat certain skin diseases, and the lawsuit alleged that these generic drug makers had raised prices by agreement 635% over a 2-year period. This litigation is about 5 years old now. It is still kicking around, and the last I saw, which was last fall, the plaintiffs had just asked the court for leave to expand the litigation and add additional defendants. And I think that provides, apart from the legal issues in this, I think it provides us with a practical example of the fact that antitrust litigation can be very time-consuming and, not surprisingly, as a result, expensive. This is a very drawn-out piece of litigation that, at least the last I looked at it, showed no signs of ending in the near future. All right, so that's Section 1 of the Sherman Act. Let's look at Section 2 of the Sherman Act, which prohibits monopolization or attempts to monopolize and conspiracies to monopolize. And so what we look at is whether the respondent, the defendant in a lawsuit possesses monopoly power, and they either acquired or maintain that monopoly power by exclusionary conduct. And that second part is important. If you're simply a good competitor, and you are able to do things more efficiently and better than your competitors, and as a result gain monopoly power, that is not a violation of Section 2 of the Sherman Act. That is simply good business, and that's not something that is going to get you in trouble with this section of the antitrust laws. The FTC thinks courts are a little lax in enforcing this provision, and it doesn't show up too often in healthcare. But let me give you an example that I think will be able to point out why the FTC thinks courts may be a little lax in enforcing this provision. So in 2013, competitors started complaining that Amazon.com was able to sell books more cheaply than brick-and-mortar competitors. Amazon would buy a book for $15 and then sell it for $10. And Amazon can do that because it sells a whole bunch of things that it makes money on, and by selling this below its cost, it allows it to weed out competitors. Now, the FTC, in its analysis, might look at this and say, well, gosh, you're allowing somebody to create a monopoly by exclusionary conduct, and that's a problem. And where they think courts are too lax is the flip side of that, where a court might look at this and say, well, actually, this sounds great. And it sounds great for consumers, because now instead of having to spend $15 or $20 for a book, they only have to spend $10. And if those other businesses go out of business because they can't compete, well, that may happen. But if Amazon raises its prices, somebody else can come in and start selling books more cheaply. That's sort of the conundrum that we run into with Section 2 claims. When do you get to the point where a monopolist can really effectively raise prices. And if you do, is it too late really to address the issue because they are the only game in town? That can be a problem if people cannot quickly come into the marketplace to balance the power of that monopolist. But let's look at this example. Let's say that Amazon had continued with this strategy and had put booksellers across the country entirely out of business, and Amazon was the only game in town. It quickly started charging exorbitant prices for books. Well, other people can fairly quickly, perhaps not immediately, but fairly quickly engage in business selling books more cheaply, and the problem thus corrects itself, all the while consumers have been benefited. All right, let's leave aside the Sherman Act now and move on to the Clayton Act. The Clayton Act is, I think, probably the most flexible of the antitrust acts as far as the enforcement by the agencies go. This is where they spend a lot of their time, is in the Clayton Act. We'll talk about a few sections, but really we're going to focus on Section 7. Section 2, and you'll often hear this in conjunction with the Robinson-Patman Act, prohibits price discrimination in the sale of goods of like grade and quality that may cause competitive injury. In other words, I can't at my gas station sell gas to people I like for $2.50 a gallon and people I don't like for $2.80 a gallon. I need to charge the same prices to like people. There is an exemption that is very important for healthcare, and that is supplies that are being purchased for their own use by nonprofit entities, and this includes hospitals, health systems, hospice providers, and so forth. So because of these exceptions, and because of, frankly, a lot of other exceptions to the Robinson-Patman Act, it very rarely comes up in enforcement. Section 3 of the Clayton Act prohibits exclusive dealing arrangements, tying arrangements, requirement contracts, but not entirely. It's only where the effect is to, quote, substantially lessen competition. That's the hallmark. And so, a lot of you have exclusive dealing arrangements. By and large, those are going to be fine. A lot of you will have tying arrangements. Again, likely fine, but if it substantially lessens competition, that's where you can run into antitrust issues. Section 7, and this is where we're going to spend some time, prohibits acquisitions. This is acquiring stock or assets that may tend substantially to lessen competition or tend to create a monopoly in a given line of commerce. Now, the agencies have a lot of latitude here. This is an incipiency, there's no time limit, and a challenge can come after the transaction. And that can be problematic, as we'll see in some examples that we're going to look at. Section 7, this is the section that the Department of Justice used to block the Aetna Humana and Anthem Cigna mergers a few years ago. And if you followed antitrust law, or frankly, if you recall from the news at the time, these were very significant potential mergers, multi-billion-dollar mergers that the DOJ successfully blocked using Section 7 of the Clayton Act. And then Attorney General Loretta Lynch pointed out their concern, the agency's concern, if allowed to proceed, the mergers would fundamentally reshape the health insurance industry. They would leave much of the multi-trillion-dollar health industry in the hands of 3 mammoth insurance companies. And we'll come back to talk about the power that dominant insurers have in the healthcare industry. But let's look at another example now, and this shows, I think, the reach of the Clayton Act and how problematic it can be for people who run afoul of it. This is St. Luke's, which is a hospital in the Boise area, acquired Salzer, which was an independent physician group. Given the size of that transaction, St. Luke's was not obligated to report that transaction for clearance to the Federal Trade Commission or Department of Justice, but nevertheless, they got wind of it. And the FTC came in and challenged the acquisition after the fact. And the FTC said that This acquisition included the right to negotiate health plan contracts, establish rates and charges, and a competitor of St. Luke's, St. Alphonsus, alleged that it would give St. Luke's a dominant market share and allow St. Luke's to block referrals that it had been getting from this physician group. And that was, in St. Alphonsus's view, a problem. So it went to court. The federal court in Idaho determined that the transaction did threaten competition and ordered divestiture of the acquired physician group. The relevant geographic market here was key. There was a big question as to whether the geographic market was limited to Boise or if it could include broader surrounding areas. And it was that smaller market that prevailed in the argument, and as a result, the remedy was divestiture. In other words, the court ordered St. Luke's and Salter to unscramble the eggs of this transaction and separate. It shows the incredible power that the Clayton Act provides to protect competition, and also the potential impact that you can have if you get into a transaction that has the potential to violate antitrust laws. So what were the important issues in the case? For St. Alphonsus, and I think this is different because you see the parties' focuses were different. St. Alphonsus was concerned about the foreclosure of competition because there wouldn't be incentives for the physician group to refer patients outside of the St. Luke's system anymore. The FTC really didn't worry too much about that. What the FTC worried about is St. Luke's would be able to get higher rates from commercial payers, and that was going to harm competition generally. And so that was really what the FTC focused on in the case. All right, let's talk briefly about another example. This one is actually only several weeks old. This is the merger of Thomas Jefferson University and the Albert Einstein Healthcare Network in Philadelphia. The FTC brought this case in February of 2020 to stop. It filed this lawsuit in Philadelphia, and it asked the court to enter a preliminary injunction that would block the proposed merger between Jefferson and Einstein until the merits of the antitrust issues could be addressed. And those issues would be addressed in a separate administrative proceeding, which was before the FTC. The FTC said that as things stood, Jefferson and Einstein were significant competitors for inpatient general acute care hospital services and for inpatient acute rehabilitation services in Philadelphia and Montgomery counties. So that's our product and geographic markets there. The merger, according to the FTC, would eliminate that competitive relationship, violating Section 7 of the Clayton Act, because you wouldn't have that robust competition. The result would be harm to patients because the merged entity could then raise prices, and insurers would pay those prices but then would pass on the costs to patients. The federal court disagreed, and most significantly, in my view, the court said the FTC's alleged geographic markets did not correspond to the commercial realities of the southeastern Pennsylvania healthcare industry. Now, the FTC appealed that to the Third Circuit Court of Appeals, but then dismissed that appeal just a few weeks ago. The FTC didn't explain why, but there are a couple things that I want to point out. First, this may have had some political involvement in it. The Commonwealth of Pennsylvania initially had joined in the FTC challenge to the proposed merger, but it settled its claims. And it settled its claims by getting Jefferson to commit to invest $200 million in Einstein's facilities over the next 7 years. The Pennsylvania Attorney General deemed that benefit to be worth the risk of allowing this merger to go forward, and so that settlement was reached. When that settlement agreement was reached, the House of Representatives for the area, Dwight Evans, had publicly stated that he was pleased with the settlement and hoped the Federal Trade Commission would drop its opposition as well. And so there has been some talk that there was political pressure on the FTC to dismiss this case. I have no idea if that's true or not, but that's at least one thought. The other reason the FTC may have dropped this case is the potential broader impact that it could have on the FTC's view of the hypothetical monopolist. And the FTC, over the last 20 to 25 years, I think, has really refined its hypothetical monopolist test and has become very much a juggernaut in making challenges to acquisitions using the hypothetical monopolist test. This is really kind of a surprising result, given the pretty broad string of victories the FTC has been able to put together using its hypothetical monopolist test to define a geographic market. And here the court disagreed and said that just doesn't correspond with the commercial realities in the marketplace. It's interesting because the court seemed to have concerns with the credibility of some of the witnesses that the FTC called, which were commercial insurer witnesses who were testifying about the potential impacts of the transaction. The court seemed not to buy their testimony. But the bigger picture, I think, is whether other courts will and other potential merger parties are going to be focused on that notion that in some instances, can we successfully argue that the hypothetical monopolist test does not correspond to the commercial realities in a given marketplace? And we'll see how that plays out going forward. But it was quite a unwelcome decision for the FTC. All right, let's move on and talk about some other sections of the Clayton Act here very quickly. Well, one other section. Section 8 of the Clayton Act prohibits interlocking directorates. And this is really sort of, I think, pretty common sense. If I am on the board of one company, I can't be on a board of a competing company. That can cause all sorts of problems if those companies are actually trying to compete and they have somebody knowing exactly what the competition is doing because they're part of the board. So Section 8 prohibits that. And then private parties can also bring claims under the Clayton Act. Section 4 allows them to do that and also allows them to recover triple the damages that they have incurred for violations of either the Clayton or the Sherman Act. And so private parties can have some pretty meaningful motivations to file antitrust claims. All right. The agencies have not left us in the dark, especially in the healthcare arena, about what their concerns are, and they have provided some pretty broad guidance. I've attached, you'll see links to a few of the pieces of guidance that the agencies have provided that can really help to orient you as you're acting and trying to make sure that you're complying with antitrust laws. First is the 1996 Statements of Antitrust Enforcement Policy in Healthcare, which was issued jointly by the FTC and DOJ. Statement of Antitrust Enforcement Policy regarding accountable care organizations, which is issued by the FTC. And then this last one, I just thought this I think has been pretty helpful to see how the FTC has acted in a variety of different healthcare matters. The FTC has sort of put together an overview of its position in various actions that have been taken throughout the country over the last several years. And so I think it's really helpful to see, as applied, what the FTC has been concerned about, and I think that's really useful to help you avoid those types of issues. So a few links there. Again, there are more. You've got additional guidelines that each of the agencies have. You have a fairly robust body of case law, and so these are by no means the only guidance out there. There's a lot of guidance that the agencies have provided for antitrust review. All right. Specifically on healthcare, though, this is a concern for the agencies, especially in the very early 2000s, as the agencies were sort of coming into their own, I think, on antitrust enforcement in the healthcare industry. Healthcare is not especially competitive because you have insurance and you have asymmetrical information, which is that one side to a transaction has more or better information than the other side. And so these two factors have made antitrust enforcement in the healthcare industry a little different than antitrust enforcement generally. But I think, again, the agencies have really hit their stride and sort of have streamlined their approach within healthcare. But these concerns do impact antitrust enforcement in different ways. The fact is, competition in healthcare is very different than competition in many other industries. I mean, consider if you're buying a car, it may be, if one dealer has a significantly lower price than another, that's probably meaningful for you as a consumer. On the other hand, let's say that you need an X-ray or an MRI, and you've met your deductible for the year, and the doctor says, well, you need to have one of these, and you say, well, which one's better? And the doctor says, well, I can get more information from an MRI, but an X-ray is probably sufficient. And you may think, well, gosh, it's probably going to cost the insurer more, but I don't care because I don't have to pay it. I've met my deductible, so I want the MRI. And so you have situations like that in healthcare that don't pop up in a lot of other industries. But again, I think the agencies have learned to determine much more efficiently how insurers fit into that marketplace. And so they do have a very, very robust enforcement regime that focuses just on healthcare. The FTC has made this clear over the last several years that healthcare is a priority area for it. I can tell you this from my own involvement in FTC investigations, that especially in the healthcare arena, in my view at least, I think they get a little bit of heightened scrutiny beyond other areas. So that's something to keep in mind as well. There is bipartisan support for increased antitrust enforcement. Now, how that looks may not be bipartisan. There are a lot of different views of how that should look, but it's something to be aware of, that both parties are pushing for increased antitrust enforcement, at least in different areas. And as a result, I don't think we're going to see less scrutiny of transactions in the healthcare arena anytime soon. How do they look at these issues? If there are antitrust issues that pop up, what do the agencies do to figure out if we have a potential antitrust violation? Well, courts have developed a couple of different ways to analyze antitrust cases. They look at them by some conduct is per se illegal, and the court just knows that I don't have to do an analysis. This conduct is anti-competitive as a matter of law. There's no need to delve into the facts of it. On the other hand, some conduct may or may not violate antitrust laws, depending on the context. And these sorts of situations are reviewed under what's called a rule of reason analysis. And that can be a very in-depth analysis, a full-blown rule of reason review, or it can be a pretty cursory review, a quick look rule of reason, which is much closer to a per se violation. But what you're looking at in a rule of reason analysis is there market power, or are there significant pro-competitive benefits that go along with a transaction that might otherwise be deemed anti-competitive? Any proposed restraint on competition must be reasonably necessary to produce the claimed efficiency. It can't be overbroad. And so we'll talk about some examples of this now, because this really is kind of a continuum. You've got per se illegal, and then as things get more and more complicated, you take a deeper look into it. And let's look at some examples. There are some per se unlawful transactions. Naked price fixing agreement. Back to my gas station in Las Vegas. If I simply go to my three competitors on the other corners and say, let's all agree to raise our prices 10 cents a gallon. That is a naked price fixing agreement. It is a per se violation of the antitrust laws. A court would not have to delve into the reasons behind that agreement. It would simply say that's per se illegal. One more interesting development over the last several years is an emphasis. It's not a change in the law, but it's an emphasis by the DOJ to go after naked no-poach agreements. And this is where you agree with your competitors that you're not going to take their employees and they're not going to take your employees. A naked no-poach agreement is a violation, a per se violation of antitrust laws. DOJ has emphasized this over the last several years and has said not only is it a violation of antitrust laws, it is a criminal violation of antitrust laws. And if you enter into a naked no-poach agreement, we will prosecute you. That was the case in the example I gave earlier about the owner of the physical therapy staffing company in the Dallas-Fort Worth area. That was a naked no-poach agreement, or naked wage fixing agreement, kind of the same thing, and the DOJ went after it criminally. So that's the sort of thing where if you have a naked no-poach agreement, that is a criminal antitrust violation, and you should not do that. Rule of reason, let's talk about that. Some agreements can have pro-competitive benefits, and so an example of this would be, for instance, an exclusive supply agreement. Yeah, if it's exclusive, other people can't benefit from that supplier. But if it allows you to be more efficient and provide services at lower cost, that can be a benefit to the marketplace in a way that that compensates for the anti-competitive aspects of that agreement. Joint ventures. Now, let's talk about some examples where parties are consolidating. This is moving on to examples of where parties are collaborating or consolidating and how the antitrust laws look at those. A joint venture, you've got separate businesses and they remain separate, but they provide a service or product jointly. So there, some examples of this, a cartel. A cartel is, I suppose, a joint venture, but it's also a naked restraint on competition. It's simply, we're the OPEC nations, we're going to agree on oil prices, and you're stuck. You can't negotiate with one of us, all of us are charging the same price. That's a cartel. It's a naked restraint on competition, and, if they weren't sovereign entities, but were private businesses in the United States, they would be violating the antitrust laws, and their conduct would be per se illegal. Joint ventures, though, can be used to provide pro-competitive benefits to consumers. And so the agencies and courts will look at whether the restraints on competition are ancillary to a legitimate purpose, business purpose. So they'll look at three things. Are the possible restraints of trade subordinate and collateral to a legitimate joint undertaking? You're not just getting together to stop competing with each other. You have a legitimate undertaking that you can't do, and this is next, on your own. Are they necessary to the success of the joint undertaking? Do you have restraints on trade? Do you have agreements that you won't poach certain competitor employees as part of a joint venture that otherwise you wouldn't be able to engage in the joint venture? Is that restraint necessary to the success of a joint undertaking? If so, it may be viable, even though on its own, as a naked agreement, it might be a violation of antitrust laws. And are they no more restrictive of competition than necessary to accomplish the pro-competitive ends? Okay, if you're going to work together, we understand you're going to have some limits on how you're competing with each other, but you can't go overboard with those limits, so you're simply not competing. Those are the factors that a court will look at in considering a joint venture. A good example of a joint venture that is generally pretty safe and frankly usually encouraged by the agency is a group purchasing organization. This allows participants to get volume discounts. You can reduce transaction costs, have access to consulting advice that each participant in a group purchasing organization may not be able to do on its own. And in fact, what the agencies have done in their guidance is set out a safety zone for group purchasing organizations, and you can see the percentages there and how that works, because the agencies recognize these can be really pro-competitive organizations. Now, let's say you're part of a group purchasing organization, you're looking at these percentages and you're thinking, gosh, we may be outside of those. Are we violating antitrust laws? Well, maybe not, probably not, as long as, you're not, as long as you're being reasonable with it. And by that, I mean, look at these factors. Members are not required to use the arrangement for all purchases of a particular product or service. The organization's negotiations are conducted by an independent employee or agent, and communications between the organization and each individual participant are kept confidential. So even if you're outside of those percentages above in the safety zone, if you're doing these things, you're probably safe in your group purchasing organization, probably not at risk for antitrust exposure. All right, mergers. This is where we see most of those Section 7 challenges under the Clayton Act. Mergers are very common, especially now in the healthcare area. It helps providers to level a playing field with dominant insurers. It helps providers take advantage of certain Affordable Care Act provisions. Just by way of example, these are some of the reasons. There are, of course, others. But despite these issues, healthcare mergers do face heightened scrutiny. And a couple of points that I want to raise on this. One, during the COVID-19 pandemic, this has been devastating for many hospitals, many healthcare systems. And as a result, some mergers have taken place, are planned to take place to address the financial fallout of this pandemic. The FTC specifically has made clear that it is not going to allow any sort of pandemic exception to its enforcement of antitrust laws. And so simply because a given hospital, for instance, has struggled during the pandemic, the agency will not provide any lower amount of scrutiny to that transaction. And it's said that it will continue to apply the same criteria that it has for other healthcare transactions. In addition, states are starting to get involved in merger clearance, and especially in the healthcare industry. Washington and Connecticut both have statutes that allow or that require certain healthcare transactions to be approved through the state. California has similar legislation that's pending right now, and I have heard of at least 2 or 3 other states where legislation was pending, perhaps defeated, but this is an idea that is gaining some traction around the country. That in addition to federal clearance for mergers, you could have clearance required at the state level, and again, that's going to depend on your jurisdiction. These are not that common right now, but it does seem to be a growing trend that states will be involved in the pre-merger clearance process in some way, shape, or form, especially in the healthcare industry. So check your specific jurisdiction to see how that might impact a transaction that you're involved in. Check that, if you're in Oregon and you have a transaction with somebody in Washington, you may be subject to that new Washington law as part of that transaction. So it's important that you keep in mind that there's potential state law clearance required as well. I did want to note, this is not just for complete mergers. It also applies to any acquisition. The Clayton Act does not just apply to a full merger of entities. The DOJ just announced a settlement with a couple entities, Geisinger Health and Evangelical Community Hospital. that related to a partial acquisition of Evangelical by Geisinger. And Geisinger had wanted to buy a 30% interest in Evangelical, and the DOJ put a stop to it and said, we're not going to allow that. Now, they ultimately settled and allowed for a lower amount for that. I think it was 7.5% instead of 30%, but also with some limits on for instance, information sharing, and limits on how Geisinger could act. Geisinger could not, for instance, take any steps to exercise control over Evangelical. It couldn't, for instance, appoint a board member. So there are some issues, even if it's not a full merger. If there's simply an acquisition of interest, that can apply. Let's talk about information exchanges. This pops up very frequently in healthcare. Statements of antitrust enforcement policy in healthcare provide a safe harbor for providers to exchange information. The scope depends on the sensitivity of the information, but here are some general principles. If you are exchanging information that's managed by a third party, that's information that's more than 3 months old, and information that is aggregated, you're probably okay. Aggregation means the information is blended together in a way that you can't tell that the information came from any particular competitor. Typically, you probably need 5 entities involved in this to have that type of aggregation. When you blend everybody's information together, you can't tell whose it is. Now, that can vary depending on the size of the organizations involved, but typically you'll need to blend that in a way that you can't tell what any particular competitor is doing. But if you're doing that, then you're going to fit within this safe harbor for your information exchange and be able to participate in that. A lot of trade associations do this type of thing, and so it's something that can be done safely. Vertical acquisitions. Now, typically, antitrust enforcement, and historically, antitrust enforcement has focused on horizontal issues, mergers between competitors. It's focused on agreements between competitors, to price fixing agreements, things like that, things where people are on the same level from a competitive standpoint. Vertical combinations, though, have become a real point of emphasis for the agencies more recently. And when I say vertical combinations, what I'm talking about is acquisitions between parties who do not compete. So, for example, a hospital acquiring a physician group, that's a vertical transaction because hospitals and physicians don't normally compete with each other. And yet, that can be an antitrust violation given the impact that it has on competition. The St. Luke's case is a good example of this, where a vertical acquisition raises antitrust concerns, and it's much more common now than it has been historically. Boycotts can be antitrust violations. This is an agreement among competitors not to deal with other competitors, not to deal with certain customers or suppliers. It's per se illegal in a few situations that I've outlined there. Outside of that, boycotts are still examined under the rule of reason, though. This comes up a lot in healthcare because you have situations like denial or termination of staff privileges, efforts by providers to prevent entry of managed care programs into a market. And so you need to be aware that boycotts have the potential to be antitrust violations. And if you have a competitor that reaches out to you to discuss denying staff privileges to somebody, your antitrust radar should ping, and you should reach out to antitrust counsel before you proceed with that. All right, joint negotiations. This pops up too a lot in healthcare, where parties want to get together to negotiate jointly. Comes up especially in the context of negotiating insurer agreements. The keys that the agencies have provided some guidance on this at a very high level. If the parties to the joint negotiations are financially integrated, where they share financial risk, or if they are clinically integrated, where they coordinate care, and there's much more to it than that. Please don't just rely on that. But if you are financially or clinically integrated, you can typically engage in joint negotiations. But be aware that if you are engaged in joint negotiations, there is antitrust risk, and you should seek advice of counsel before you do that. Let's skip to state law here really quickly. Some states have certificates of public advantage laws that allow states to approve mergers that may otherwise be anti-competitive, and they do that in return for promises that hospitals, for instance, will make investments that will benefit the public. They'll control costs in a way that will make the transaction palatable for the state. This can be really beneficial for parties because it preempts federal antitrust enforcement, which makes your life a little easier. You don't have to worry about the FTC coming and knocking on your door with a lawsuit. The FTC, not surprisingly, doesn't really like these. Says that generally they're misguided and risk harming consumers. Is that the case? Maybe, maybe not. I think it really depends on the context. In rural areas where there's not adequate infrastructure, these can be a real benefit, both to the state and to consumers. So what's next? Really briefly, we are almost certainly going to see some kind of pretty major antitrust reform over the next couple of years. Let me focus on this, the proposed Competition and Antitrust Law Enforcement Reform Act of 2021 that Senator Klobuchar has been pushing. This is really, I think, where antitrust is probably headed somewhere. It may not be this sweeping, but this is probably where we're headed, is to some sort of reform like this. It would lower the standard under the Clayton Act for prohibited mergers, and that means that it's going to be harder to show that a merger is appropriate. Instead of the agencies having to show that the merger would substantially lessen competition, they only have to show that it would create an appreciable risk of materially lessening competition, a much lower standard. It would apply to monopsony power, and that is Amazon. This is a situation. It's not the sellers that are getting together and saying we're going to charge this price. It's the fact that you've got one buyer that has so much power it can dictate terms to sellers, and that's what an entity like Amazon can do. It's big enough. It can dictate terms to sellers. And under this amendment, it would clarify that the Clayton Act would apply to monopsony power. It would also shift the burden for merger approval in many cases. In certain situations, the merging parties would have to demonstrate that their merger would not create an appreciable risk of materially lessening competition, whereas in the past, that's been the agency's burden to prove the harm to competition. It would also broaden the definition of market power. And again, this would catch a lot more transactions that are currently being caught for antitrust enforcement. So with that, I'll wrap it up, and thanks for sticking with me if you're still around. The few conclusions, antitrust analysis, it's not always a bright line analysis. In fact, it's frequently not. It's frequently just how comfortable you are with the risk and whether the risk is material or insignificant. Second, agencies are looking to protect and encourage competition, so keep that in mind as you enter into transactions. And for the foreseeable future, the healthcare industry will be in the crosshairs for the agencies, and so that's kind of where we're going to leave this for today. If you do have questions, feel free to call or email, and I'm happy to chat with you. Hope that you have a wonderful afternoon. Thank you so much for participating today.